I guess our request is either A, that the state be required to plead with more specificity what it is that they think is reckless, or alternatively, the reckless portion be struck from the indictment.
All right, this is cause number 24 DCCR 0094. And for the record, Mr. Gertz is joining us via Zoom. And sir, you are Austin Jones.
Yes, Your Honor.
And Mr. Jones is also joining us via Zoom. The case is set for trial to begin with jury selection next Monday afternoon. It is the only case left on the docket, so it will be the number one case for trial next week. Mr. Gertz filed a motion to quash the indictment, so I wanted to go through that so everybody knows where we are for next week. Mr. Gertz, I want to ask, it appears you're asking, it says you're asking the court to excise the defective portions. If you'll explain what you're specifically asking for and what you think is inappropriate.
Sure, Judge. So as you know, aggravated assault of this nature, where it pleads serious bodily injury, allows the prosecution to plead intentional conduct, knowing conduct, and then reckless conduct. In this instance, the problem is the reckless portion of the indictment is not matched with appropriate language specifying the nature of the recklessness as required under the statute, under Article 21.15. And so I guess our request is either A, that the state be required to plead with more specificity what it is that they think is reckless, or alternatively, the reckless portion be struck from the indictment going forward, such that they can only proceed on intentional and knowing conduct.
Mr. Hoffpower?
Your Honor, we're tracking the statute. This is how we file all aggravated assaults. They all have, those are in the statute, the three.
Can y'all hear Mr. Hoffpower?
Am I speaking loud enough?
There's the.
I can hear him fine, Judge.
Okay.
Knowingly, I mean, this is part.
I can hear him fine.
The statute of aggravated assault, it always has knowingly, intentionally, knowingly, or recklessly. I'm not sure why, in this particular case, we need to excise that. I mean, that's always how we file that, and it's tracking the statute.
So from
I'm
my
sure.
reading of the indictment, and we're all obviously making assumptions, isn't something that we should do, but I would think that the reckless, to me, it would read, that any of those, intentional, knowing, or recklessly, that the action of those is the shaking with the defendant's hands. So how is that not specific enough? I guess my question, Mr. Gertz. Oh, I can't hear you. You muted yourself.
Sorry, I apologize. The answer is, Judge, this case that I cited in my my motion, State versus Rodriguez, requires the state to provide the acts and circumstances surrounding the allegations that the state intends to prove were reckless. And it goes on to give an example of saying recklessly discharging a firearm by pulling the trigger on a firearm which contained ammunition and was operable is not sufficient. That kind of language that just says that essentially an injury was caused by this mechanism is not sufficient to describe why it's reckless. What's the gross deviation from the standard of care that an ordinary person would normally apply here that he has knowledge of? And that's just not contained in the pleading.
I'll respond quickly, Judge.
Yeah.
And I'm not sure about this particular case, but I have had one of these before in regards to reckless deadly conduct, where you understand, like, there's a felony and a misdemeanor, and recklessness is a part of that particular charge, which makes it whether or not, whether it's a felony or whether it's a misdemeanor. But to my knowledge, there's not analogous to what we're talking about in our case, which is an aggravated assault with a deadly weapon, in which we do give I think we pled the case sufficiently.
I think if it had, so I'm looking at Article 2115, which obviously says that it must specifically have to do with this one, recklessness and criminal negligence, that the act or acts relied upon to constitute recklessness must be alleged. I'm going to deny the motion to quash. I believe the indictment alleges sufficiently the acts of shaking with defendant's hands as the potential or alleged reckless or intentional or knowing. But I think there's enough specificity for the defense to know what is alleged that his client either did or omitted from doing with regard to the recklessness. So I am going to deny that motion. Is there anything else that you guys know of that we need to kind of be prepared for before jury selection on Monday with regard to any other pretrial issues?
No, Judge, as far as I'm concerned, that was my only issue.
Okay, so we will, if anything comes up, just y'all know how to get in touch with me. Let me know. We can take care of it either. If it has to be taken care of before board hour, we'll do it. If not, we'll do it that afternoon after we go through jury selection. All right, so we'll see y'all back here.
And Judge, just so you know,
Go ahead.
Judge, just so you know, I may raise this issue again as the trial progresses. I just needed to preserve it 10 days in advance under the statute. And so I understand the court's ruling, but depending on what the evidence is, et cetera, I may raise it again.
Okay.
Because I anticipate what's going to happen, Judge, is that the experts for the state are going to try to allege intentional conduct. And again, part of the problem with this statute is it allows them to do all three. And so I'm just letting the court know that I'm going to be likely raising it again, depending on what the evidence is. So.
Okay. We'll take that up at the appropriate time if it happens. Mr. Gertz,
I appreciate it. Thank you, Judge.
Would you have your office send an order over for me to, for that motion to quash? They did. Never mind. They already did.
I'm sorry, that's my fault.
Okay.
All right. Thank you both. You're excused, Mr. Jones and Mr. Gertz. See you next week.
Thank you, Judge. We'll see you Monday. Thank you.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.